Hello friends, in the series on the income tax cases, today we will discuss a case which is on section 276C. Section 276C talks about willful attempt to evade tax, etc. Meaning thereby that if the revenue is able to establish that the assessee has attempted to evade the income tax or any interest or penalty thereon, then the prosecution proceedings under section 276C can be initiated against him. In the present case, the issue before the Punjab and Haryana High Court was that if the assessee suo motu determines the self-assessment tax, but there is some delay on the part of the assessee to deposit that tax, whether in these type of circumstances, whether it will be deemed that the assessee has done some willful attempt to evade the tax and whether the prosecution proceedings are justified in that case. This issue has been very well taken up by Honorable Court in the case of Hansa Metallics Limited and others versus Deputy Commissioner of Income Tax, and this case is reported in 472 ITR at page number 737 and the date of the judgment is 22nd January 2024. The facts of the present case are like this. The present case relates to a limited company for the assessment year 12-13. Because this case relates to the assessment year 12-13, at that time, the return filing date was September 2012 for the assessment year 12-13. The assessee determined the self-assessment tax and uploaded the return, but some tax was not deposited. This tax was deposited in the next year on 10th July 2013, but this tax was deposited before any demand notice from the revenue or before any show cause notice issued to the assessee for prosecution proceedings. When this tax was deposited by the assessee suo motu in 2013 July, after that in 2014, the revenue issued 2 show cause notices to the assessee by saying that why the prosecution proceedings against the assessee should not be initiated. The assessee replied that section 276 is applicable only when there is some willful attempt on the part of the assessee to evade tax, interest on penalty, because since the assessee has suo motu determined the tax, suo motu paid the tax before the issue of the notice, and the interest has been accepted by the revenue. So in these type of circumstances, by no stretch of imagination it can be concluded that there is any willful attempt on the part of the assessee. But the assessing officer was not convinced with this submissions, and the matter went up to the court, and the court said that in the present case section 276C is applicable if there is willful evasion or attempt at evasion of either tax, penalty or interest. Every delay of payment of income tax or interest would not amount to evasion of tax. Self-assessment tax payment with interest has been accepted by the revenue and the show cause notice has been issued after the payment of the tax. So in the present facts and circumstances, it is not established on the part of the revenue that the assessee has done any willful attempt to evade the tax. Every delayed payment of tax cannot be treated as willful evasion of tax. So the court quashed the prosecution proceedings. Friends, the great lesson from this case is that it has been seen in the general practice that the assessees take it very casually, that they do not deposit their tax in time, they deposit with interest, and even it has been seen very commonly in the payment of the advance tax that the advance tax is not taken very seriously, they delay it very casually. So from the reading of this case, it appears that if the assessee takes it as a practice to delay the tax, then this provision can land the assessee into prosecution proceedings and the assessee has to stand in the queue with the other criminals to get the bail or something like that, and the assessee has to face the trial. So always make it habit that deposit your tax on time and if you are not able to deposit it, then at least inform the department that there are serious financial crunch with the assessee and it will be deposited with interest so that it can help them in prosecution proceedings. At the end of this video, once again I am repeating the name of the case. The name of the case is Hansa Metallics Limited and others versus Deputy Commissioner of Income Tax, and this case is reported in 472 ITR at page number 737 and the date of the judgment is 22nd January 2024.